Good day, everyone. This is Rami Al-Shabal. I'm an SJD candidate at Wake Forest University Law School. Today I'm going to talk about business contracting, a comparison between Saudi and US contract law, points of symmetry and difference, and ways of drafting contracts for parties of two states in business contracting. The common features for basic contract requirements, usually, are apparently offer, acceptance, consideration, and the capacity of two parties, or the legal capacity of the two parties of the contract. And we could say that the Saudi legal system is based on Islamic law. And after analyzing the American contract law, it appears that both laws, Saudi and American, have common features. They both have in common elements to contract requirements, or elements such as offer, acceptance, and consideration. However, although these similar requirements or elements of contract laws of these two different states are different in what they mean and what they require. Today in this presentation, I will show how these two legal systems have common features or common apparently features, and when analyzing them closely, they appear to have differences. Furthermore, when applying these two laws to same facts, which will be presented as a case study, it will show how outcomes will differ due to the difference in two laws. So the Saudi contract law gives freedom of contracting in economic or business contracting without the interference of jurists or judges, provided certain basic requirements are met as discussed before. And there are basic provisions that has to be or shall be avoided. Provision of riba or usury, interest, and provision of gharar, which is unconscionability or excessive uncertainty. All requirements that are compulsory in contracts are based on two basic provisions in Islamic contracting. These two elements void any contract that ever exists. Consequently, any requirement for conducting a contract has to avoid these two provisions. So having to go to the basic elements that formulated the requirements is better than discussing contract requirements that exist in different kinds of contracts. So mainly Islamic law, or the Saudi law, which is based on Islamic law, gives you freedom of contracting with having consideration of the basic elements of contracts and avoiding the main basic two provisions of usury and unconscionability or excessive uncertainty. So usury is the first element that any contract in Islamic law has to avoid, or it will be void and illegal. The rationale behind this provision of usury is to seek justice in economic and social practices. Justice is the objective that is supposed to be occurring while conducting contracts. However, in reality, there are some practices that are injustice and need to be modified. Usury is the translation of the Arabic word riba that has a broader meaning than just an interest in a loan. It accommodates meanings like unlawful increase that is illegal, and the riba in Islamic jurisprudence is mostly defined as an increase in the principal with no consideration. The contract in Islamic law is a contract of grants that should be offered and accepted between parties. However, in American law, where contracts can be an exchange of promises, is different than contracts in Islamic law. The second provision, which is gharar, or excessive uncertainty, that prohibits aleatory contracts, tend to confine transactions as much as possible to what exists or can precisely exist in future. This second provision in Islamic law, which is similar to unconscionability or excessive uncertainty, it is the meaning of speculation and gambling, where one party gets a higher profit than what he gave or he or she gave to the other party. Gharar is usually a concern and tested when a price or the exchange good of the contract or both of them are not determined. However, in a deeper understanding for this concept, it does not prohibit contracts for products that do not exist right now at the time of contracting. Rather, it prohibits contracts that have a high uncertainty of appearing in the future. Furthermore, lack of knowledge about the exchanged good, whether it exists or not, its quality or time of performance, are all aspects that raise the concern of gharar or unconscionability. There are some exceptions for this prohibition in some contracts, like forward contracts and construction contracts. However, although this exception is given, there are several requirements that lowers the possibility of uncertainty or excessive uncertainty or unconscionability. Now we'll be exploring a case study for the provision of usury and unconscionability, and it's going to be a comparison between the US contract law and the Saudi contract law. So this was a case that was presented before a US court after the World War II, and it was given a decision, and when applying the Saudi laws on the same facts, it could show and give a different outcome. So this case of Vatsikis versus Dimatsis, and the facts were the plaintiff, Vatsikis, loaned the defendant, Dimatsis, 500,000 drachmae, which is a currency used in Europe, in one of Europe's states. In exchange for the loan, the defendant signed an instrument promising to pay plaintiff $2,000. The 500,000 drachmae currency were worth approximately $25 at the time. So it's merely a loan of 25 and in future returning back 2,000. Way different in the exchange. The defendant, Dimatsis, entered into the contract due to conditions created by World War II. The defendant could not access money and property owned in the United States. So, knowing that defendant was in financial distress, the plaintiff agreed to lend defendant 500,000 drachmae. So the issue that was raised and the question that was raised in front of the court was the consideration of the contract inadequate. So there might be other issues that were presented in court for the case. However, in this presentation, we're gonna consider analyzing the consideration this issue because it's relevant to our topic today. And the rule that was applied in this case says, or the law that the court will apply says, in American contract law, inadequacy of consideration alone will not void the contract. So, when analyzing, the defendant was arguing on an unequal contract grounds. She argued without evidence of fraud, duress, or misrepresentation. And as in American law, if a contract party fails to show elements that void the contract, like fraud, duress, or misrepresentation, it is hard to say that the contract is void. As long as there is consideration and no elements of voiding the contract were proved, then the contract is legally enforceable. Okay, analyzing the same case and the same facts by applying the Saudi laws. So as it appeared, it shows that there was an offer and acceptance, which are the first two elements. These elements did meet the three requirements. for the offer and offeree, which are the legal capacity. And there was entering to the contract without any force. So both parties own the exchangeable goods. And regarding the consideration, the exchange goods are legitimate exchange goods that are not prohibited from being exchanged by public policy. So the basic formality of the contract is existing. So in Saudi law and American law, the basic apparent formality of the contract is legal. However, when considering the two provisions in Saudi law that void any contract, this contract might be or apparently is going to be void. So the contract is a loan, and initially the loan was worth $25, and when paying it back, it will be paid as $2,000. So this is a clear usury or clear interest that significantly voids the contract. And when analyzing the second provision, so if even let us say if the it could violate the other provision, unconscionability. Let us see the fact that Batsikis was exchanging the 500,000 drachmae currency to a dollar currency that was worth $25 for a return of $2,000. So this is a very high inequality and favorable. So usually exchange contracts have a fraction of difference in currency exchange, which does not appear clearly unless there is a very high amount of money. And here the 500,000 drachmae is worth merely $25, and Batsikis is asking for a return of $2,000 US, which is 80 times more than the price of currency that was exchanged for. This is a very excessive and high favor and inequality of interest of Batsikis that is violating the provision of unconscionability in Islamic law. Hence, this contract is also void due to the high range of inequality of the contract that is favoring one party. So even if the contract did not violate the first provision of the usury, if the completion of the exchange counter value is not delayed, having this high inequality in favoring Batsikis is a violation of unconscionability or excessive uncertainty that voids the contract. So having in mind those two contract laws, and apparently they have the same elements, however there are a couple of differences. In addition to these apparent elements, the Saudi law based on Islamic law has two provisions that has to be considered while business contracting between companies or corporations of the two states or even merchants. So this was a summary of the two basic elements of U.S. contract law and Saudi contract law, and a way to make international trade business between two states easier. And I wish it was helpful. Thank you everyone for listening, and please send me any remarks, comments, or questions to my email at alshara14@wfu.edu. Thank you.